Nothing from the state.
Nothing from the defense.
Counsel, as I have previously, in the words of Judge Pyle, these are opening statements, not arguments, counsel. Okay. Bring them in. Good morning, ladies and gentlemen. Thank you for promptly being here. I appreciate it. I had legal matters that I had to take up with the attorneys in this matter. And again, I just want to thank you for your patience and thank you for your service. Can you please swear the jury?
Please stand and raise your right hand. The correct response to the oath is I will. You shall well and truly try the case 2022 GS 232194, the state versus Zachary David Hughes, indicted for murder and possession of a weapon during the commission of a violent crime, 2024 GS 235425A for burglary first degree, 5412 for harassment, and 5413 for conspiracy, and a true verdict rendered according to the law and the evidence, so help you God. I will. I will. Thank you. Please be seated.
Ladies and gentlemen, you are now the jury in this case, and I'll take a few minutes to tell you something about your duties as jurors and give you some instructions. At the end of the trial, I will give you more detailed instructions on the law, and those instructions will control your deliberations. The criminal case has been brought by the state of South Carolina, and I will sometimes refer to the state as the prosecution. The state is represented in this trial by Solicitor Walter Wilkins and Jake Hofert. The defendant is represented by his attorneys, Mark Moyer and Andrew Moorman. The defendant has been charged by the state with murder possession of a weapon during the commission of a violent crime, burglary first degree, harassment, and conspiracy. The charges against Zachary David Hughes are contained in the respective indictments. The indictment is simply the description of the charges against Zachary David Hughes. It is not evidence of anything. The defendant has pled not guilty to these charges and denies committing the crime. He is presumed innocent and may not be found guilty by you unless all of you unanimously find that the state has proven his guilt beyond a reasonable doubt. South Carolina law makes the jury the finder of facts. You 12 alone are the finders of facts, and it will be your duty to decide from the evidence what the facts are. You will hear the evidence, decide what the facts are, and then apply those facts to the law I give you at the close of this case. That is how you will reach your verdict. In doing so, you must follow that law, whether you agree with it or not. The evidence will consist of the testimony of witnesses, documents, and other items received into evidence as exhibits, and any facts on which the lawyers agree or stipulate. The same law that makes you 12 the finder of the facts makes me the judge of the law, and our rules of evidence control what can be received into evidence. When a lawyer asks a question or offers an exhibit into evidence and a lawyer on the other side thinks it's not permitted by the rules of evidence, that lawyer may object, and that simply means that the lawyer is requesting that I make a decision on a particular rule of evidence. South Carolina law forbids a trial judge from making a comment to a jury about a fact in a case. Therefore, because it may be necessary for me to comment on a fact in applying our rules of evidence, it may be necessary for me to talk with the lawyers out of your hearing by having a bench conference while you are present in the courtroom or by excusing you from the courtroom. The purposes of these conferences is to decide how certain evidence is to be treated under the rules of evidence and to avoid confusion and error. I ask you, be patient during these breaks. Certain things are not in evidence. Statements, arguments, questions, and comments by lawyers representing the parties in the case are not evidence. Objections are not evidence. Lawyers have a duty to their clients to object when they believe something is improper under the rules of evidence. You should not be influenced by the objection. If I sustain an objection, you must ignore the question or exhibit and must not try to guess what the answer might have been or the exhibit might have contained. If I overrule the objection, the evidence will be admitted, but do not give it special attention because of the objection. Testimony that I strike from the record or tell you to disregard is not evidence and must not be considered. Anything you see or hear about this case outside this courtroom is not evidence unless I specifically tell you otherwise during the trial. Finally, some of you may have heard the terms direct evidence and circumstantial evidence. Direct evidence is testimony by a witness about what the witness personally saw, heard, or did. Circumstantial evidence is indirect evidence, that is, it is proof of one or more facts from which one can find or infer another fact. You may consider both direct and circumstantial evidence. The law permits you to give equal weight to both, but it is for you to decide how much weight to give to any evidence. In deciding what the facts are, you may have to decide what testimony you believe and what testimony you do not believe. You may believe everything a witness says or only part of it or none of it. In deciding what to believe, you may consider a number of factors, including the following: the witness's ability to see or hear or know the things the witness testifies to, the quality of the witness's memory, the witness's manner while testifying, whether the witness has an interest in the outcome of the case or any motive, bias, or prejudice, whether the witness is contradicted by anything the witness said or wrote before trial or by other evidence, and lastly, how reasonable the witness's testimony is when considered in light of other evidence which you believe. It is my responsibility to rule as a matter of law as to whether certain testimony is admissible. But once the testimony is admitted, whether or not you believe it is solely for you to determine. To ensure fairness, you as jurors must not talk among yourselves about this case or about anyone involved with it until the end of the case when you go to the jury room to decide your verdict. Do not talk with anyone else about this case or about anyone who has anything to do with it until the trial is ended and you have been discharged as jurors. Anyone includes members of your family and your friends. You may tell them that you're a juror, but do not tell them anything about the case or discuss it until after you have been discharged as a juror. Do not let anyone talk to you about the case or about anyone who has anything to do with it. If someone should try to talk to you, please report it to me immediately. During the trial, do not talk with or speak to any of the parties, lawyers, or witnesses involved in this case. You should not even pass the time of day with any of them. It is important not only that you do justice in this case, but that you also give the appearance of doing justice. If a person from one side of the case sees you talking to a person from the other side, even if it is simply to pass the time of day, an unwarranted and unnecessary suspicion about your fairness might be aroused. If any lawyer, party, or witness does not speak to you when you pass in the hall, ride, the elevator, or the like, it is because they are not supposed to talk to you or visit with you pursuant to my instructions. Do not read any news stories or articles, watch TV about this case or about anyone involved with it, or listen to any radio or television reports, podcasts, anything of the like about this case, any social media, or about anyone involved with it. Do not do any research on the internet about anything in the case or consult blogs or dictionaries or other reference materials, and do not make any investigation about this case on your own. This is your duty as the jurors in this case. Do not make up your mind about what the verdict should be until after you have gone to the jury room to discuss this case with your fellow jurors. Keep an open mind until then. I'm often asked about note-taking. You are not able to take notes during the trial of this case, and the reason is that I want you to pay close attention to each witness as he or she testifies and not be fixated on taking copious notes. The first step in the trial will be the opening statements. The state in its opening statement will tell you about the evidence that it intends to put before you so that you will have an idea of what the state's case is going to be. Just as the indictment is not evidence, neither is the opening statement evidence. Its purpose is only to help you understand what the evidence will be and what the state will try to prove. And after the state's opening statements, defendant's attorney may, if he chooses, make an opening statement, and at this point in the trial, no evidence has been offered by either side. Next, the state will offer evidence that it says will support the charges against the defendant. The state's evidence in this case will consist of the testimony of witnesses and may include documents and other exhibits. I remind you that the defendant is presumed innocent, and the state must prove the guilt of the defendant beyond a reasonable doubt, and the defendant does not have to prove his innocence. After you have heard all the evidence on both sides, the state and the defense will each be given time for their final arguments. I just told you that the opening statement by the lawyers are not evidence, and the same applies to the closing arguments. They are not evidence. In their closing arguments, the lawyers for each side will attempt to summarize and help you understand the evidence that was presented. The final part of the trial occurs when I instruct you about the rules of law that you are to use in reaching your verdict. After hearing my instructions, you will leave the courtroom together to make your decisions. I will inform you when you can begin deliberating. It is your added duty, Ms. Foreperson, to preside in the jury room and be the jury spokesperson here in court. It will also be your duty to write the verdict, but I will give you further instructions about that at the conclusion of the case. We will now begin the trial. State.
Your Honor, may it please the court.
Good morning, ladies and gentlemen. My name is Walt Wilkins, and myself, along with Jake Hofreth, we are the prosecutors in this case. This is Detective Jared Sparkman and Master Deputy Blake Wolf. They're the co-lead investigators in this case. I want to thank you for your service and thank you for giving us the opportunity to present this case to you. The state has the obligation to prove the charges beyond a reasonable doubt. And that's the standard that you're going to hear from the judge, you're going to hear throughout your deliberations and throughout this trial. We have to prove the case beyond a reasonable doubt. And there's a lot of folks in this courtroom right here that you see. And so we are the prosecution. We represent the state. We have the honor of representing the state in this particular case. The defendant sits over there. That is Zachary Hughes along with his attorneys, and they represent him in this particular case. But there's many more other individuals in this case. We have the court reporter. She's very important. She is taking down everything that we're saying, recorded, so we can have a record of this entire case at its conclusion. And so that's what she'll be doing, and she'll also be marking exhibits. So if you see her over there writing on things, that's what she's doing. She's marking the exhibits in which we will identify things that we will be presenting to you for your review. This is Madam Clerk. She's involved with a lot of paperwork and handles all the evidence that we submit into the court. So she'll be handling all the exhibits that you will get to review upon your deliberation. And of course, we have the judge up here. And if you'll notice, the judge is a pretty important person. He's got a black robe. He gets to sit a little higher than the rest of us. And there's a reason for that, because he is the referee in this case. And he's going to be calling balls and strikes. He's going to be telling us what the law is. And when one of the parties has an objection, he's going to say whether you're right or whether you're wrong. And because there are rules in this courtroom, ladies and gentlemen, the rules are officiated by the judge to make sure that we maintain the rules and decorum in this courtroom and the evidence is presented to you in the proper way. But the most important people in this room, ladies and gentlemen, are you. As the judge said, you're the triers of fact. You decide what the facts are. And the great thing about serving as a juror is that you don't leave your common sense at the door. You get to bring it with you in here. And you get to listen to the testimony that'll come right from this chair right here. And you get to look at the evidence that's presented in your deliberations. And you can see it along the way of how this case progresses. You'll hear different kinds of evidence. So the judge said, you hear direct evidence and circumstantial evidence. They're both very powerful pieces of evidence. They can be used in any way in which you accept them. Direct evidence is simple. It's something that somebody can see, taste, or smell, something that they see. If you see somebody commit a violent crime, that's direct evidence that they saw that person there. Circumstantial evidence could be just as powerful. For example, if you look outside before you go to bed and you see your lawn nice and green, and you wake up and it's covered in snow and there are footprints walking through the snow, well, you know that somebody walked through your yard from the time you went to bed and the time you woke up. You don't know who it is, but you know somebody did because you can see footprints. You can derive information from that to form a logical conclusion. Another good example of circumstantial evidence is DNA evidence. If you have DNA in a certain location, you can derive that that person was at that location at that particular time. Even though no one may be testified that they actually saw him there, but the DNA shows that he was or she was there at a particular time. It's very powerful circumstantial evidence. So, ladies and gentlemen, this case is about the murder of Christina Parcell. And the state intends to prove that Zachary Hughes did in fact murder Christina Parcell. And you have a number of charges that you're going to be deliberating on. You have harassment charges, you have a burglary first-degree charge, and you have a murder charge. Harassment is basically doing something that would intrude into the personal life of somebody, causing mental anguish. Burglary first degree means you went into somebody's home for the purpose of committing a violent crime. And then, of course, murder is an angry heart. We have to show that Zach Hughes had an angry heart. He was mad. And you can derive that information from any of the testimony, any of the evidence that we have that we present to you. So in this case, ladies and gentlemen, you're going to hear about a number of characters. The main character is Christina Parcell. She was murdered on October 13th, 2021. And she was living in the Canebrake neighborhood with her sister, Tina Parcell, and Christina's daughter, Aida Melo. They were living in that neighborhood in a house in Canebrake. And Christina Parcell had been going through a very tremendous child custody dispute with John Melo since Aida was 3 years old. At the time, Aida was 9. For almost 6 years, they had been battling custody over Aida Melo. And that custody dispute raised to a certain level beginning in October of 2020 when John Melo and Aida Melo went to Italy. And John took Aida Melo to Italy, and Christina fought to get her back. And in April of 2021, Christina obtained Aida's custody. And they came back from Italy, and that's how they ended up living in the Canebrake neighborhood. So the question is, how did Zach Hughes become involved in this case? Well, Zach Hughes had a relationship with John Melo starting in about October of 2020, around the time when he left for Italy. And that relationship grew. And it grew to the point where Zach Hughes began inserting himself into this custody battle at the behest of John Melo. And they began doing things like sending photos of her to the neighbors in an effort to shame her, an effort to show that she's a bad mother. And as the custody dispute it elevated into a situation where custody might not go in John Melo's favor. And at that point, Zach Hughes made the ultimate decision. Ladies and gentlemen, I hold in my hand the indictments from the grand jury charging Zach Hughes with harassment and burglary first and murder. And the grand jury, true bill of these cases, they came out, and these are the charging documents. And while the defendant at this point in this case is certainly clothed in innocence, once you hear the evidence from that chair, you hear the evidence that's presented to you, you're going to find beyond a reasonable doubt, and the evidence will show that Zach Hughes is a cold-blooded killer. And he committed murder, he committed harassment, and he committed burglary first. Thank you.
Thank you, Your Honor. May it please the court, the defense is going to defer opening until our case. Thank you.
Which is your right. State. All right, Your Honor. The state calls Sarah Young.
Please stop right